In this particular case, I was looking at the transcripts of the hearing, and they had a number of hearings because it took longer than expected. But in the first part of the hearing, the respective clients was presented by counsel, and the counsel brought some really good issues in terms of defending the client. And this is, in the transcript. Then when I looked at the subsequent transcript of the continuation of this hearing, I noticed that the attorney was not there. So he took it upon himself to represent himself on a hearing for a emergency temporary injunction against a very experienced litigator. And obviously the litigator, the attorney, was able to present the evidence, the witnesses, and present all the elements. And then the prospective client, attempted to cross-examine the witnesses. It didn't go well because he does not do this for a living. He doesn't know the proper way of cross-examining a witness. He did not bring new witnesses to present his case. The attorney would have done that through a subpoena. Long story short, the prospective client lost that hearing, and the court granted the temporary injunction to the plaintiff, which would prevent him to do the work that he does. And in this particular case, there was no specific geographic range or time limitation. In fact, when I saw the time limitation was exceeded by a year from what the original non-compete was. But then it complicated matters first. This is bad enough. Part of the order that came in this particular case, it was for him to transfer the assets of the company that is owned by his wife. Yet the company was never a party to the lawsuit, which makes it interesting. He himself does not own the company. The way they were able to somewhat connect those dots is through some type of letter that they receive from the wife authorizing him to conduct this transaction, which that in itself brings a lot of legal issues about the legality of this particular letter, which I'm not going to go into.